Good afternoon and welcome to the second webinar in our data protection series. Just a few housekeeping points before we kick off. There's going to be an opportunity to ask questions at the end, but you can also use the Ask a Question tab throughout the presentation just to post any questions that you have. This is the second webinar in a wider series about data from the Commercial International Disputes team. This webinar focuses on the law of confidence. The next and final webinar in our series is going to focus on the consequences of data breaches, and you're going to be sent a link to this webinar shortly after the conclusion of the broadcast. Your speakers today are me, Matt Phillip, and John Mackenzie. We work in the Commercial International Disputes team, and we regularly advise clients about confidential information, including what qualifies as confidential, how to protect it, and the action that can be taken when it's been misused. In today's webinar, we're going to focus on the law of confidence, and as a broad general principle, the courts have said that a duty of confidence arises when confidential information comes to the knowledge of a person in circumstances where they have notice or have held to have agreed that the information is confidential, with the effect that it would be just in all the circumstances that they should be precluded from disclosing that information to others. Put simply, the circumstances must make it clear that the information is confidential. Traditionally, there hasn't been a limit imposed on the types of information that can be protected, but the courts have pulled together four main groups and identified them as trade secrets, personal information, artistic and literary confidences, and state secrets. The format of today's webinar is shown on the screen. We're going to start by looking at what makes information confidential and how this is properly defined. And we'll then go on to look at how a business can ensure that the necessary quality of confidence that information must have to benefit from legal protection can be maintained. We're then going to go on to consider the circumstances that are required to create an obligation of confidence and the evidence that's needed to prove that confidential information has been transferred. At the outset of a dispute about the misuse of confidential information, it's important to look at the evidence that's already available in order to try to assess the strength of the claim. In some cases, preventing misuse is going to be the obvious priority. However, there are some other circumstances where it might make more sense to try to attempt to recover and preserve evidence in order to build your case before taking steps to prevent the misuse. Finally, we're going to consider the legal remedies that can be used to protect this information and to prevent misuse. Remedies can be broadly split into two categories, civil remedies and criminal proceedings. Civil remedies include the use of undertakings by the parties, either to each other or alternatively by giving undertakings to the court, injunctions or interdict, and damages for the loss that's been suffered. There are also various criminal offences contained in statute like the Computer Misuse Act 1998, the Data Protection Act 2018 and the Bribery Act 2010, but today's webinar is going to focus on the civil remedies. As the law is very similar in Scotland and in England and Wales, the general principles that we're looking at today are applicable in both jurisdictions unless we indicate otherwise.
So the law of confidential information is used as an additional layer to the protection that information that falls outside the usual protection offered by intellectual property rights such as copyright, patents or trademarks. In some ways the law on this area is based on a very simple moral standard, and that is if someone has said they will keep it secret, they should do so. Traditionally, in order to raise an action for breach of confidence, there will need to have been an initial confidential relationship. However, more recently it's been recognized by the courts that the law of confidence needs to be developed to reflect changes in society, technology and business practice. Nowadays there are two different interests capable of protection: privacy and confidential information. For the purposes of today's webinar, the focus will be on confidential information, but I'll touch briefly on the right to privacy and the misuse of private information. The English courts developed the common law of England and Wales to recognise a cause of action of misuse of private information. This arose from the case of the supermodel Naomi Campbell suing a newspaper for publishing photographs of her leaving a drug rehabilitation clinic. The quote shown on the slide makes clear that now the law imposes a duty of confidence whenever a person received information he knows or ought to know is fairly and reasonably to be regarded as confidential. Even this formulation is awkward. The continuing use of the phrase duty of confidence and the description of the information as confidential is not altogether comfortable. Information about an individual's private life would not, in ordinary usage, be called confidential. The more natural description today is that such information is private. The essence of the tort is better encapsulated now as misuse of private information. To give a recent high-profile example, you will no doubt all be aware that the Duchess of Sussex, Meghan Markle, is suing the Mail on Sunday alleging infringement of copyright, breach of Data Protection Act, and misuse of private information for its publication of parts of a letter she wrote to her father. Her father shared the letter with the newspaper. What this case does is highlights that there are a range of legal remedies when bringing a claim for breach of confidential information. In the recent Scottish case from the Outer House of the Court of Session, BC and others against the Police Service of Scotland, Lord Bannatyne was satisfied that there is a common law right of privacy in Scotland. In this case, police officers sought judicial review of a decision by the Professional Standards Department of Police Scotland to allow WhatsApp group chat messages to be produced in disciplinary proceedings. The judge decided that, given the characteristics of WhatsApp, a reasonable expectation of privacy arose. The judge contrasted it with other social media platforms where any member of the public can gain access to the content of the platform, and thus messaging is entirely open and public. In contrast, the membership of a WhatsApp group is controlled in a sense. The police officers were ultimately unsuccessful for other reasons, but the case does show that the general principle is the same north and south of the border. Now, despite growing recognition by the courts that an individual can, in certain circumstances, enforce the right to privacy, it is more common that the court is asked to intervene when there is an allegation that someone has misused information that is confidential. But what does confidential actually mean in this context? To come within the definition of confidential information, three factors must be present. First, the information must have the necessary quality of confidence. Second, the information must have been disclosed in circumstances which shows that there is an obligation of confidence. And third, there must be an unauthorized use or disclosure of that information. If this test is met, then the person receiving the information is not allowed to use it to the prejudice of the one giving it without their consent. This includes disclosing it to third parties. The protection can arise even in circumstances where no confidentiality agreement is signed, but in practice it's obviously sensible to have some sort of terms written down to provide clarity about what can and can't be done with information that's received.
So, as John mentioned, there are three parts to the definition of confidential information. The first is that it has what's called the necessary quality of confidence, which means that it can't be public knowledge. The necessary quality of confidence is often highly fact-specific. Some examples of information that may be confidential include statistical information, business plans, scientific discoveries, recipes, whether or not they're apparent from the end result, and financial information. And one term that's often used in connection with confidential information is know-how. That describes the practical information resulting from experience and testing that's secret, significant, and useful. To qualify as confidential, the information must also be imparted in circumstances which show that there is an obligation of confidence. A classic situation is where the information is provided to a trusted advisor. In those circumstances, the advisor is then not allowed to capitalise on that information for their own benefit. Thirdly, the information can't be used or disclosed without the consent of the person to whom the duty is owed. It's also worth noting that if the recipient of confidential information discloses the information to somebody else and they're aware that it's confidential when it's disclosed to them, then an action for breach of confidence can also be brought against that third party, for example, in the Meghan Markle case that John just mentioned. The test that's applied by the courts is to look at the reasonable man and to ask if such a person who is standing in the shoes of the recipient of the information would have realised upon reasonable grounds that the information was being given to him in confidence. The relationship between the person giving the information and the recipient can also give rise to an obligation of confidentiality. For example, employees are duty-bound to keep their employer's secrets. When thinking about protecting confidential information, where possible, it's always better to try to avoid a situation where you have to rely on a duty being inferred, and instead the duty should be explicit by either using standalone confidentiality agreements or including confidentiality clauses within a contract before the information is disclosed. One of the most common problems faced in many industries is that confidential information has to be shared with employees so that they're able to perform their own roles. But this also then creates the risk that information is passed to a competitor for financial gain, or that the employee leaves the business and then uses that information that they've obtained as a basis to set up in competition. When it comes to employees, there can be both an implied and an explicit duty of confidence not to disclose trade secrets or information. There's an implied duty in all employment contracts, regardless of how senior the employee is, that employees will conduct themselves with fidelity and good faith. In this context, that specifically means that they need to act honestly towards their employer. They should disclose to the employer all information relevant to its business. They can't make secret profits from the employer's business. They need to respect the confidentiality of the employer's commercial and business information, and they can't compete with the employer's business. When it comes to the extent of the implied confidentiality duty, a lot depends on the type of information that's involved. For example, information which is clearly confidential and the employee has been expressly told is confidential can be protected with a covenant for the duration of the employment. Of particular relevance for senior employees, specifically directors and other employees who have a fiduciary duty to the company, is the duty to disclose their own misconduct should they disclose that confidential information. Separately, following the termination of employment, the default position is that only one type of business information is going to remain subject to that duty of confidentiality, and that's trade secrets. This is true regardless of whether there's an undertaking not to disclose, because the employer enjoys the same level of protection for a trade secret regardless of whether the employee is current or former.
Now, a recent case serves as a warning to businesses of the significant consequences of a data breach by an employee. In the case of various claimants and Morrisons supermarkets, a senior IT internal auditor employed by Morrisons copied the personal data, including payroll data, of a large number of employees onto a USB stick. However, he then took the USB stick home and posted the data on the web. The employees claimed damages from Morrisons for misuse of private information, breach of confidence, and for breach of statutory duty under the Data Protection Act. We'll discuss this case in more detail and consider other aspects of it during our next webinar in this series looking at data breaches and their consequences. For the purposes of this webinar, the important points are that the Court of Appeal has held that the cause of action for breach of confidence is not excluded by the Data Protection Act in respect of wrongful processing of data within the ambit of the Data Protection Act. The Court of Appeal also held that the judge had been correct to hold that the Data Protection Act does not expressly or impliedly exclude the possibility of vicarious liability of an employer for their employees' actions in these circumstances. Now, the case has been appealed. Permission to appeal to the Supreme Court was granted in April, and the appeal was in fact heard on the 6th and 7th of this month, and we are anxiously waiting for the judgment. But unless it's overruled, the law is as stated by the Court of Appeal. It's a very important case for a number of reasons, and we'll be providing updates as soon as the judgment is issued. Even with effective policies and procedures in place, information can still be taken and misused. Often it's not clear whether information has been used for unauthorized purposes, and if so, who is responsible, how it was obtained, and what's been done with it. For these reasons, an important first step is often to investigate so that these questions can be answered. It may seem obvious, but often clients will make do with what they first discover. Now, what we're going to do is look at some of the different ways to find out more about what's happened to any confidential information. These days, confidential information is invariably created, stored, and transferred electronically. Documents stored electronically create risk because they can be transmitted more easily and circulated more widely than hard copy documents. Where it's suspected that an electronic document has been taken or misused, the first step is to understand the source of the document. The flip side of the ease of with which documents might be transmitted is the ease with which their use or misuse can be recorded and monitored. This makes recovery of evidence proving wrongdoing easier and more likely. Vast amounts of data can be retrieved from any computer, tablet, phone, or network, even where attempts have been made to conceal the actions that have been taken when the information was misappropriated. This type of investigation is often conducted internally, but that will depend on the skill set of the IT team in the business. If a large volume of data needs to be reviewed, or if the data to be reviewed is in multiple formats, like audio files or images, it can often be more efficient to instruct an external forensic IT firm who can deal with these challenges. The ability to recover information that's been deleted or corrupted often surprises people, usually the person who's taken the information. There are examples of hard drives being recovered from burnt-out buildings and then reconstructed for use in evidence. As well as looking at emails sent, downloaded files, and other electronic actions, the investigator can also review other information such as print logs to see what documents might have been printed and when, so that if the information is in hard copy form, that can also be tracked down.
One thing to note is that these types of review often only go so far. They tend to work when you have possession of all of the data and you're really just trying to find the proof amongst that mountain of information. But often a party is going to have good grounds to suspect that confidential information is being misused by a third party. And in order to prove this, they need to recover evidence from them or from someone else. There's often a concern that the person who's misused the information is going to take steps to destroy or try to conceal the evidence if they're made aware of a potential claim. In those circumstances, it's possible to apply to the court and seek permission to conduct what's commonly referred to as a dawn raid or a search and seize order in order to recover evidence. The recovery of evidence in this way is governed by sections 33 and 34 of the Senior Courts Act 1981 in England and Wales, and Section 1 of the Administration of Justice Scotland Act 1972 in Scotland. The English process has developed from the case of Anton Pillar that's shown on the slide. For in order to be granted, the claimant must show three things. Firstly, that they've got an extremely strong prima facie case. Secondly, that the respondent's actions have resulted in a very serious potential or actual harm to the claimant. And third, that there's clear evidence that incriminating documents are in the respondent's possession and there's a real possibility that they might be destroyed if notice was given. The bar in Scotland isn't quite as high. In Ted Jacobs' engineering group against Robert Matthew, it was described as a prima facie intelligible and stateable case. The general process is broadly similar in both jurisdictions. What happens is an independent party is appointed by the court to perform the search. In England, this will be a solicitor acting as the supervising solicitor, and in Scotland, it will normally be an advocate acting as a commissioner. They're authorised to attend a particular location and to search for documents that fall within a specific category that's been approved by the court. The supervising solicitor or commissioner then prepares a report of the search and a list of all of the documents that have been recovered. In England, the documents are made available to the claimant for use in their claim straight away, whilst in Scotland the documents are then consigned to the court until the court makes a further order about what to do with those documents. We don't really have time to go into the specifics of Dawn raids today, but they can serve as a very useful purpose for the recovery of documents to support a claim before the action's been raised. And if it didn't exist, it may not be possible in certain circumstances to recover that information at all, which could frustrate an otherwise good claim. As they're usually granted without the knowledge of the other party and have been described by the courts as a draconian order, the court tends to scrutinise the claimant's position very carefully in order to ensure that the scope of the order is appropriate. And in both jurisdictions, the claimant is also required to provide undertakings that they're going to indemnify the third party for any loss that's suffered as a result of the search.
Now, the next area we're going to look at is the remedies available to a party whose confidential information has been misused. When you have evidence demonstrating misuse, the next step is deciding what to do. There are a wide range of measures that can be taken to stop the misuse of confidential information. Unlike the remedies that are available for the enforcement of intellectual property rights, such as under the EU Directive on the Enforcement of Intellectual Property Rights of 2004, the remedies for breach of confidence derive from the common law. Before formal action is taken, a first step is to seek undertakings. Undertakings will normally be given before an action is commenced and are often demanded and granted after the action has been raised as an alternative to interim orders. Undertakings are probably the simplest solution. An undertaking is given by the party who has unauthorized access to the information and will state that they undertake not to use the confidential information in the future, as well as a number of other protective measures. The willingness of both parties to agree to undertakings will depend on the circumstances. On the one hand, the party providing the undertaking is often being asked to agree to wide-ranging and potentially invasive provisions that could have a significant impact on their business. On the other hand, the party receiving the undertakings may be distrustful that they will be complied with given the circumstances, namely allegations of misuse of information. However, if the undertakings are not agreed, then normally the only alternative is court. Litigation almost inevitably results in an increase in time and costs. There are also reputational considerations for both parties. One has allegedly misused the information, and the other one has apparently failed to keep it confidential in the first place. In our experience, offering and agreeing undertakings at the outset can be a very useful way to bring parties back from the brink of litigation. As a potential defendant, it will normally be in your interest to try and delay the immediate action being taken against you. If information has been used inadvertently, or you are unsure of your position, this buys time to better understand the claim being made. By consenting to carefully worded undertakings, you can investigate what's happened to better understand the extent of any potential liability. Even if the dispute cannot be completely resolved, it means that when proceedings are brought, you're in a position to properly defend them. If you are the potential claimant, it is important to remember that, particularly in cases relating to misuse of confidential information, there is a significant upfront cost involved if a claim is raised. This is because there will often be application for interim orders and document recovery, and so there can be a lot of front-loading of work. Even if you're ultimately successful, you're only going to get some of your costs back from the other side. This can make undertakings an attractive alternative. However, when considering the terms of the undertakings, you should be careful to ensure that you don't agree to waive claims in consideration of the undertakings that are given. The concept of consideration is an English one, but the consideration should just be refraining from raising proceedings. It's also important the right to seek further relief from the court for injunction or interdict or indeed damages is preserved. Undertakings can be offered at any stage, even after proceedings have been raised. This might be because another party has not been given notice of the claim, or additional evidence has come to light, or because the terms of an undertaking could not initially be agreed between the parties. It's still possible for contractual undertakings to be agreed between the parties at this stage. However, an undertaking can also be given by the defendant to the court. The main difference between an undertaking given to the court and a contractual undertaking is that there is an immediate sanction for breach of an undertaking to the court. A breach is considered to be contempt of court and can, in theory, carry a prison sentence. In contrast, the remedies for breach of a contractual undertaking are the same as any ordinary breach of contract.
So, if an undertaking isn't offered or if it isn't accepted, the alternative is to seek a court order that prevents use of the document in the short term. This is known as an interim injunction in England or an interim interdict in Scotland. The general effect of the order is the same in both jurisdictions. The court orders the defendant not to make use of the confidential information, and if they don't comply, then it's similar to the undertaking given to the court in that it's contempt of court and faces quasi-criminal sanctions. Whilst the general effect is the same in both jurisdictions, the tests that are applied by the court in deciding whether to grant the order are slightly different. In relation to interim injunction in England, the case of American Cyanamid against Ethicom set out the criteria that the court must consider when it's deciding whether or not it should use its discretion. The first issue it needs to consider is whether there's a serious question to be tried. This is a requirement for the party to demonstrate that there's a real prospect of succeeding in their claim. The second is the balance of convenience, and this is where if a party has demonstrated that there is a serious question to be tried and that damages aren't an appropriate remedy, then the court will consider where the balance of convenience lies between the parties. This involves considering a number of different factors, including whether making the order is in the interest of justice, the preference of the court to maintain the status quo, and whether more harm is likely to be done by granting or refusing the order. And then the third issue that I just touched on is the adequacy of damages as a remedy at trial. This technically forms part of the assessment of the balance of convenience, but it's typically considered separately by the court. If an award of damages at the trial or the payment of an undertaking by the other party in advance of trial would be an adequate remedy, then generally no interim injunction should be granted, regardless of how strong the party's claim appears. To obtain an order for interim interdict in Scotland, the party must satisfy the court that it has a prima facie case, and that's the equivalent of the serious question to be tried test in England. And they also need to show that the balance of convenience favours the order. In Scotland, there's generally less emphasis placed by the court on whether damages would also be an adequate remedy. Even if damages can be claimed, then the court will often still be willing to grant the order if it can be shown that the balance of convenience in a more general sense favours this. One other difference in the approach that's taken by the English and the Scottish courts is in relation to whether the application can be made without notice. In England, the court will generally speaking expect notice to be given to the other party, even if that's just a very short period of notice. No notice at all is normally acceptable to the court where there's a concern that by giving notice you would enable that third party to defeat the purpose of the injunction. In Scotland, it's far more common for interdict to be granted without the notice being given to the other side. However, in Scotland, it's also possible for an individual or a company to lodge what's called a caveat with the court. A caveat acts really as a trigger warning, and it's a document that requires the court to contact the solicitor who's instructed for that person or entity if an application is made for a pre-service order like an interdict. The solicitor can then take instructions and can appear in court to oppose the application if their client wants them to do that. The English courts have also recognised a specific type of injunction called a springboard injunction. This is a remedy that's designed to prevent a former employee from using confidential information as a springboard to get a head start with their new employer. The springboard injunction is unusual because, unlike most other forms of injunction, it isn't really about preventing a future wrong. The springboard injunction is seen more as a way of preventing the former employee from getting an unfair advantage. In the sense, it's more of a punitive measure for that person's conduct. It tends to be temporary in nature, and it will last for around 6 to 12 months. The length of the injunction is approximate to the length of time that the court considers it would have taken the former employee to gather the information lawfully without using the confidential information.
No, I think we're just one slide ahead of ourselves. So on the topic of the third and final set of civil remedies we're going to look at, that's the question of damages. And specifically damages and accounts of profits. The first issue to consider when looking at a claim for damages is the extent of the loss suffered, perhaps obviously. It can, however, in cases involving confidential information, be difficult to identify the loss with any level of accuracy. One example of how a party might do this is by looking at the value of contracts that they believe were lost as a result of the information used. The next step is to determine whether that loss is actually recoverable from the party in breach. In the case of universal thermosensors, the court noted that there was no irrefutable presumption that business gained by a party following their misuse of confidential information derived from the wrongdoing. There can be many other reasons why a loss has been suffered. This recognises a common defence used by, for example, the former employee, and that is that business would have been lost anyway, or the customer would have followed me anyway because of the good relationship that I had with them. Countering that defence can be quite challenging. For these reasons and others, quantifying the damage suffered can be very difficult. As an alternative, the claimant can go for an account of profits. Rather than focusing on the damage caused to the employer or the claimant, this remedy looks at the defendant's profit as a result of their misuse of the information. An order can be sought from the court requiring the defendant to pay the profit made over to the claimant or the former employer. Now, both financial claims and an injunction or interdict can be sought in the same action. They're not exclusive remedies. The idea is that the injunction, permanent injunction, protects the information going forward. The damages compensate for the losses suffered as a result of the breach. Now, it's normally far easier to enforce a contractual obligation than rely on the general law, and so thinking about potential issues in advance and entering into agreements accordingly is a critical way to protect your valuable confidential information. We'll close today's webinar by looking at some of the more practical steps that can be taken to protect confidential information. The general steps to establish and maintain confidentiality include restricting access to confidential information and labelling truly confidential documents confidential. You should limit access to areas where confidential processes take place. Consider limiting early disclosure, so keep back information that is truly a trade secret until you reach an advanced stage of negotiations, and think about whether it's essential that it is disclosed at all. Tell your employees how to keep information confidential. For example, not discussing company business in public places or meetings, and taking care when using laptops or tablets in public. Of course, have IT policies and security protections in place, particularly if your company operates a bring your own device scheme. This might seem obvious, but demonstrating that you have policies in place and that they are being enforced is helpful evidence if action is being taken to respond to a breach. Keep audit logs and records to show what projects each employee or consultant has worked on. And where documents are in a digital format, use passwords and encryption software to restrict access to sensitive information in databases. It is possible to prevent documents from being forwarded or printed by the recipient. For example, Microsoft Outlook has a feature called Information Rights Management that allows messages to be created with customized permissions. This makes onward transmission of the content more difficult and reduces the chance of the information being disseminated more widely than is intended. If you don't have the technology, then a header or footer included in email should state that the email should not be forwarded on. You should also have policies in place relating to monitoring the use of emails, photocopiers and other devices that are used by employees. These policies can help to minimize risks. An example of this might be the banning of use of USB sticks or disabling CD drives at individual workstations to take practical steps to stop material being copied. Not all of these suggestions will be appropriate for every business, but the important thing is to think about what is needed in advance and then make sure that the process is followed.
So that concludes today's webinar, and there's now some time for you to ask questions. As I mentioned at the beginning, questions can be submitted by typing in the Ask a Questions tab, and a link to this webinar is going to be sent to you following the conclusion of the broadcast. You can also catch up on any of the previous webinars in this series and any of the other series that are being run by the firm at the moment by following the link on your screen. We don't have any questions at the moment, but what we'll do is we'll leave that open for a couple of minutes after the webinar, so if you do have any questions, please feel free to just drop us a question in the Ask a Question tab, and we can pick them up separately with you afterwards. Otherwise, I think we'll just close the webinar there, so thank you very much for